Volete collegarvi per vedere se sta andando bene? Non mi collego io per vedere se sente l'audio.
Non ci si collega. Ma questa cosa
Sì, mi dica lei quando siamo... Quando volete partiamo.
Avete preso il caffè?
Prego.
Ok, questo è
Okay. Good morning. I think we can start the roundtable. Just a few words to thank Eduardo Alves and Marco Esposito for inviting me at this seminar, and also the youngest colleagues, Emilia Davino and Eufrasio Siena. The seminar, I think it is very important now in these times. I heard the presentations of the different groups, and all of them were very interesting. Congratulations for your presentations. I would like to say just a few words about the issue of the seminar, COVID-19, a pressure test for occupational health and safety. I think all the legal systems of the countries involved in the seminar have been affected and have been affected by the pandemic. And I think during the presentation there was a big issue about the reaction of the sources of the law to the pandemic, to COVID-19. But I think we have to stress that obviously the seminar was concentrated on labor law, but I think that there is a background issue, which is the reaction of the legal systems as a whole, of the reaction of the general system of the sources of law. For instance, as the Italian colleagues know, during the COVID-19 pandemic, a state of emergency was declared, and that state of emergency has changed a lot about the system of the sources of the law. I think that it was really interesting. All the presentations were really interesting. I would like to add something about the last presentation, since I think there was another actor which has not been nominated, underlined during the presentation, and the other actor is the role of the judge, the role of the judges. I don't think that the role of the judges maybe is not a major role during the pandemic, since the pandemic needs to have a prompt reaction of this legal system, and so it was necessary to have other kind of sources of the law, other kind of laws, and something like that. But in other legal systems which are outside the European Union and the Europe as a whole, so we have the United Kingdom, which is not a member of the European Union, but is a crucial country in Europe. So I think so. But in other legal systems, the role of the judges was very prominent. I had the occasion to read a paper by an American colleague, Charles Szymanski, which was exactly about the role of the judges, since in a proper federal state, such as the US, and which is also a common law system, the role of the judges was very important during the pandemic, and there is also, and though the common law system was stressed by the pandemic, and so the other federal state which we have dealt with, you have dealt with during this seminar, which is the Germany. I think there is a strong difference between that federal state and the federal state of the United States with reference as regards pandemic, since if I understood well, in the German legal system, all the regulations was centered on the role of the state, of the federal state, of the central government. While in the US it is completely different. Now I have to stop to say just another thing about the role of the European Union. I don't know if you have dealt with the role of the European Union during these days, but as you know, the role of the European Union against the pandemic, as a reaction of the pandemic, was a prominent role from the financial point of view. Since, as you know, there was the next generation EU and so on, and there was a role. There was also a role played by the European institutions such as the Council and the Commission, but it was a role concentrated, played on the ground of state aids. The measures concerning state aids was tempered during the pandemic. And there was obviously the European Union played a prominent role in the freedom of movement. As you know, the freedom of movement was suspended, was more or less suspended during the first stages of pandemic. So I think now it's time to start our roundtable. The first speaker will be Juan Carlos Alvarez Cortés, who is from the University of Malaga, Spain. I think the best time choice is 10 minutes for your presentation. Thanks.
Good morning, thanks to everyone, especially for the organization of this university. I'm going to follow my own notes because my own security is speaking English and it is better for you, I'm sure. I'm going to speak the so-called social shield in Spain. How our government combined social protection measures with occupational risk prevention during pandemics. The rules of in prevention of labor risks during pandemic, as we can see, are similar in all of countries. I think that is maybe by the influence of ILO, WHO, or EU standard of recommendations. For that reason, in this brief talk, the point of view will be changed. Let's focus on how Spanish social protection system contributed to prevent the massive spread of COVID through the labor market. This came about with the special regulation of two social security benefits, temporary incapacity and unemployment benefits. About the first temporary incapacity, as you know, in other European countries, when the worker become ill or suffer an accident, they can obtain, if eligible, of meet requirements a social security benefit during sick leave. Okay? At the beginning of the pandemic in Spain, it was adopted a special regulation. On one side, sick leave is due to COVID-19 contagion as an accident at work. Obviously, if it is proven that the disease was contracted exclusively through work, it will be classified an accident at work. But unfortunately, the difficulty or impossibility of proving that contagion occurred at work suppose that all these benefits were denied by the public GP, by the public service doctor. In all the cases, for staff working in health or social health center, if they suffer COVID, the law classifies it as an accident at work without any proof. Okay. In Spain, also, when an employer doesn't offer PPE for their workers, they have to pay them a special charge of temporary incapacity benefit between 13 and 50% plus. As you know, during the first months of pandemic, there weren't enough face masks, gloves, PPE for workers in essential services. But the labor inspectorate never sanctioned employers for that breach because labor inspectorate was working at home and never check, and never control, and never visit the companies. On the other hand, this is an exceptional situation of assimilation to an accident of work for temporary incapacity. It was considered that if you contracted COVID, or you are near of a person who was positive in COVID, or you couldn't go to work because the lockdown, the government considered that you were in temporary incapacity. Okay? And you couldn't go to work, and the state paid you a social security benefit of 75% of your wages. Okay. Finally, the second type of benefit that help or contribute to the economy and the families to survive to economic effects of the COVID were the employment benefits. Okay, to avoid spreading the contagion, the government banned commercial or training activity in non-essential activities in lockdown, as you know, similar in all our countries. Employers could suspend or reduce working hours of contracts by force majeure or by economic, organizative, or production-related causes. In those cases, employers didn't have to pay contributions, and workers could get unemployment benefits with no requirements. The only one is to sign a contract before 14th of March of 2020. Okay. The idea was to protect all the employees in Spain. In Spain, the government adopted nine types of special unemployment benefits to avoid the spread the virus and preserve the life of workers. The most important, first, for workers in companies affected by pressures of suspension of reduction working hours, including part-time workers and permanent seasonal employees. Also, extraordinary employment benefit for domestic employees. At this moment in Spain, domestic employees, they don't have protection for unemployment. A recent rule of the European Court of Justice condemns Spain for discrimination because 95% of these groups are females. And for that reason, Spain government now have to adopt a special scheme of employment benefit for this group. Also for artists in public performance or technicals and auxiliary personnel in the culture sector. Sorry, I'm in Spanish. For bullfighting professionals. I don't like for bullfighting. I think it's a crime against animals, but there are 8,000 people in Spain that work in this sector, and they have more power than the domestic employer were are for 400,000 workers. It's madness. It's Spain. And the last but not least is the protection of the self-employed workers due to cessation of activity during pandemic. To sum up, during the first phase of pandemic, 4.5 million workers and 1.5 million self-workers were covered by unemployment benefits to avoid spread conditions. Thank you very much.
The presentation was really interesting. I would like to stress just a few things. The first one is that Professor Professor Cortés, Alvarez Cortés, has underlined the role of the ILO in the pandemic, which is very important, also in a different ways in respect with the role of the national government, national systems. And he has also reminded us that some works, some jobs cannot be done from home. But the case of the labor inspectors is not the only one. But this is a very important point, since otherwise someone thinks that all the kinds of jobs can be done from home, but this is not true. In my university, which is the Federico II, there was the case of the librarians. How you can do the work performance of as a librarian from home. This is a very, and also the librarians. Yes, and so there was a big issue in my university about librarians, since the how they can work from home on using agile work or instruments like that. Thank you again for other two things. The fact that you underline the role of the special the unemployment benefits for special categories of workers, which are not only typical of Spain, apart from good finding. Okay, and also it is very important to stress the response of the legal system to self-employed people, to independent contractors, which, in my opinion, have been the weaker categories of workers, also during the pandemic. So thank you again. Now it's the turn of France. We are going to listen to the presentation by Benjamin Davosville from the University of Strasbourg, and Nicolas Moisard from the same university as well. So they are sharing the presentation. So you first. Okay, you have to go this way. Okay. Okay. With the laptop. Okay, the floor is yours.
Thank you, colleague. Thank you, Eduardo. So I won't repeat all we heard this morning. So my slides are not codes for the future. We have now a lot of conference about learning from COVID crisis. I'm not sure that's possible, but we can evaluate some move, perhaps permanent or in this situation. So in France, you heard we have a general framework in labor code and in case law about duty to of the employers to answer health and safety of workers, obligation of means, not of results. And Benjamin will tell you about new sources of law. I'm not sure that those are delicious sources, but we saw emerging new sources in labor law during this crisis. The context in France, we had a high level of vaccination despite inequalities in part of France or between the populations. That's very important. Part of workers were not so many vaccinated than the other. And we have the development of soft law protocol. Will have to say okay about this soft law. My colleague told us about the importance of church. During all the crisis, the balance between private life and health and safety protection has moved. Administrative church, civil church, constitutional church, not even for workplace, but for every situation. Health protection, constitutional goal was always at first. And who was responsible for this protection in the firm? the employer. So it increased a lot the power of employer. We talked together this morning about work at home, telework. In France, we had always several procedures. And it is always sometimes very complicated. Since the crisis, this is very fast. The employer decide who is in telework. So by collective agreement, but even in situation of emergency. So we must be careful in this balance, and perhaps in the balance with another risk, with protection of personal data. I know that in Germany that's very more important than in France, but we all had, I think perhaps everybody here, on our phone, the green pass, the vaccination pass, and we could give to the employer information about our own health. How could he control? Would he control all the employees or certain employees? A lot of questions raised about those paths. In France, there is two key measures at work: compulsory vaccination for specific groups, or extension of health pass, which became in January a vaccination pass. So Macron was very happy when vaccination increased, but that's very funny. When President Macron made a speech, the announcement of each speech had increased the rate of vaccination. So we are children in France. We're waiting the Pope to do. The vaccination obligation, that was an obligation for employer to monitor compliance with the vaccination requirements with the risk of penalties. But there was big consequences on employment contract. I would stress about that. If there is a suspension, but which type of suspension? When a worker refuses to show his health green pass or to be vaccinated. In France, he stayed at home with no remuneration. But was it in fault? Was it against the common interest? It was in a way in the law, this measure. And with a potential discrimination on the religion or belief, sometimes people refuse to vaccination because of their own belief. They're right or wrong, I won't say. And the question is about the level of control on objective disturbance caused to the company for perhaps a dismissal. We saw in France, with this obligation of vaccination, a high tension on hospital staff. When only two people missing in a service, it increased, it disturbs enormously the organization of the service. I would like to extend what I wanted to say about the community of work, the consequences of this crisis on the community. What is the link between health and safety and this sense, the spirit of the community? We saw people alone, more and more people alone with teleworking. It increased sometimes mental health problem, feeling of loneliness, and a problem to measure the workload. We need some precise things to measure the workload. We have, for management in France, we have to do it. But I think with teleworking, we have a national agreement in France. This is a necessity. The separation between private life and professional life disappears. Meeting, we all know that. Meetings are now at midtime or in the evening by Zoom. There is new goals, very important goals for labor law, protection of the person, protection of secret privacy, protection of medical data. That's very important for you to defend own private life. So I don't want to repeat all has been said this morning. We could speak perhaps after about general measure, about employment, if you like. Okay, let's my colleagues.
Passing a crisis like COVID-19, the way of thinking about outcome. Pressure test for health and safety. I think that's the point. Do we really believe in the usefulness of our framework? Do we really believe in it? And I will use the example of our working council with 3 questions in 3 minutes. So, do the employer have to consult the work council? You already know the answer. There is no clear answer in our labor code, but the judge said that the works council should be involved, associated, or consulted about the evaluation of the. And second question: how consult the works council? Before COVID-19, the principle was consulting by meeting at a workplace, face-to-face. But during the COVID-19 fact, enabled consultation via video conference or instant message without any restriction. And in my opinion, it's problematic because it's nonsense to believe that that using WhatsApp, Signal, or Telegram, it's a good way to discuss such subjects like health and safety. And third and last question: when consult the works council? According to the French code, appropriate timing is required. But during COVID-19, a question and answer published by the government said that consultation a posteriori was available. But what does it mean if an employer is unable to decide alone, to implement the decision and later consult the work council? It means that it's no more consultation, it's just information. So finally, on one hand, we're trying always to involve more the employee representatives in health and safety. But on the other hand, in time of crisis, we all, the government, do not really take their opinion into account. So that's the key question, one of the key questions. What role do we ultimately want the employee representative to play, especially in time of high danger for health and safety? This is one of the reasons I have been so much interested by the recent Brian's report and presentation during the week. And thank you for your attention.
Thank you to the French colleagues who has said some important things as regards the role of judges, especially in times of pandemic crisis. And also, I would like to stress the importance of the issue of balance between private life and professional life during the pandemic, which is at the very root of working, for instance. And I found very interesting also the connection with privacy, with personal data protection during the pandemic, and also the role of the collective of the works councils during the pandemic, which is very important also in France. Now it's the turn of the Netherlands. The presentation will be shared by Tony Aspers from the University of Amsterdam and Frans Pennings from the University of Utrecht. So maybe Tony first. Okay. So, yes, we are online.
No problem. No problem at all. I'm used to it. Well, I would like to give some reflections on the basic structures and concepts used in OHS systems in the countries, because it will be worthwhile to look how the OHS policy has been shaped by law or by mutual agreements or by other instruments, and to see whether COVID has brought a difference in the approach in the countries as to tackle the problems, and more referring to the specific COVID things, but being part of the structure of the OHS structures and laws in the country. What I find interesting is, and that's, I try not too much to refer to the Dutch situation, claiming that will be the best you can choose, so that's not my goal. But what is interesting is to see that all you mentioned, that in the law, the duty to care is kept in the general obligation of the employer, due to the European community, or union, that time community, because they put it in as a principle and as a principal goal of regulating occupational health and safety. Well, we did it, and then I'm proud to say that we did it 3 years before the European Union did it in the Directive, because we have abolished a whole set of laws relating to all kinds of hazards, accidents, and stuff, and things like that in the law. So we had a booklet of regulation, and then we abolished all of them at once. And we stick to a new approach. It is the care of the employer, and we involved social partners, trade unions, and employers, but also works councils, to find a way of more accurate standardization of what is happening in a factory, in an office, and so on. So not that all those general standards placed in the part of law, but that means that there's a shift of power, of course, from the national government to basics, I would say, the employers, the employees, the representatives. But the students has very good explicitly said that we have a layered structure, but the most important part of the layer is the last one, the catalogs. Because what the policy was that you have to put some instruments and some goals and what kind of instruments you can use, but they didn't place specific concrete norms in the laws, because they say, well, it will change every week or once in a year or 2 years. So we leave it to the parties themselves to give a more concrete content to the various standards and norms to be respected in certain firms or in a sector of firms and so on. Well, that's quite easily to say it's a kind of a privatization of the OHS legal system, because we put it to the parties and say, you have to regulate it. And we are completely confident that you are doing, even you are in a better position to do it, because you know what is happening in the sector or in the enterprise. That was a big shift of approach to the social party. But that means that you give a lot of confidence to the social partners that they can regulate it in a way that protection of workers is really respected or not. So wait and see what happens. Well, that is one part of what is happening in our country, and it is interesting to see whether it is COVID-proof, because in COVID times, perhaps it becomes much more difficult to leave it to the parties themselves, to employers and employees or representatives of them, to regulate what to do in case of COVID-19. But Frans will explain to you the shift that we have made in our minds in the Netherlands, the shift of mind that we went from the social partners and the employers associations to the government and the legislator. And that's very interesting to see that we made that shift. But there is another issue that I have to stress, is that together with privatization, you are individualizing the enforcement of those rules and standards. So you are also reliable that you trust social partners and even the individual employee, that they protest and claim that the standard is not respected by the employer. But then the problem of course will arise: which employee take the risk to start a claim against his own employer because of OHS violations? So, and that you see, in my view, and that you see more in particular in the COVID situation, because you are individualizing more or less the obligations to keep to the measures of the state or what else to the individual, whether it is an employer or an individual employee, because there are no straight forward standards and rules to do that. And that means that we have to think about what kind of structure of legislation do we use. Whereas you heard from other countries, they have a lot more laws by parliament, the official legislator. In the Netherlands, you only have this kind of real legislation, and it doesn't go into standards, norms, and things like that. It's a general way of doing. And that will be interesting whether that you can do in times of pandemic as well. Leave it to the. And the last point, that will be difficult because of talking about works councils, we usually, I would say, we have very strong works councils, but one moment later, I would say, but they are not effective. And so that means that you trust that the works council has real power to negotiate with the employer about these kind of measures, that you have to be very strong, and you are still dependent as members of the works council usually of your own employer. So take that into account when you are really power. A specific problem will arise when you talk about small and medium-sized enterprises. Perhaps they don't have a works council, and if they have, they are not powerful. And if there is a kind of a representation, then you have to wonder whether the power of the employer is much higher and much severe than what the employees together can negotiate with the employer. So there will be, it is a good test and a good assessment to see whether one approach, leave it to the parties, or the other approach, regulated in regulation approved by Parliament and things like that. That will be a good choice for the future, I would say, also dealing with the pandemic situation. Oh, that's the first part.
Indeed, the theme of this conference is COVID-19 pressure test for health and safety, and that is a very interesting topic, and we have discussed this past days. But I would like to state
that the COVID-19 has especially been a pressure test for Social Security. In fact, it fits also with Juan Carlos' presentation, because it's still uncertain to what extent COVID-19 has permanent effects on health and safety. That's in fact the conclusion of what you said. Also for Social Security, I don't think the effects will be permanent, but in any case, during this pandemic, which was in fact unexpected, we see that in any case in the Netherlands, Social Security rules were changed dramatically. So normally the rules are very strict, the conditions are strict, and the supervision is strict. Now there were very generous rules in the Netherlands. And Social Security was also extended to new groups, so not only employees, but also self-employed. So in our country, we do not have special rules, special schemes for the self-employed. Self-employed always said we don't want these special schemes, we can give ourselves, but now they were dependent on the schemes. Of course, we have to explain that the government obliged them to close their enterprises, so you cannot call this a normal risk anymore of entrepreneurs. But in any case, they became reliant on the government. Social Security means, in this respect, a very broad approach, because the Social Security was focused mainly on the employers. Employers were reimbursed the wage costs for 90% of the wages when they lost at least 20% of the turnover. And the advantage of this is that they did not have to explain what the reason is for the loss of turnover. So it could also be a decision to take preventive measures, or it could also be that they suffer from the economic developments, whatever. The only criterion was the reduction of the turnover, and they were paid the majority of the wages. In this respect, for the employers that made use of this, a lot of health and safety issues were not put so much on the agenda, so they were softened, one would say. Like the discussion, we presented that when people cannot work in Netherlands, they receive 70% of the wage if it is because of illness, and 100% if it is for another reason, is not so very relevant if the employer is reimbursed wage costs, because in that case, the employer always has to pay the full wage to the employees. Also, there was no recourse necessary to unemployment benefits, because the employer simply had to pay the wages. The only condition was that the employer was not allowed to dismiss workers in this period. So it was really a retention of jobs scheme. If the employer dismissed a person, then he has to reimburse the subsidy for that worker plus 50%. Kind of fine, it's not the correct word, but it's kind of fine if the employer did not really obey the conditions. So that was a very generous scheme, and this was especially relevant for enterprises that had to close their activities, like restaurants and sports schools and theaters, etc. And also those companies that had no essential activities, because the general recommendation was that people have to work at home if it is not necessary to come to the office. In addition to the scheme for the employers, there was also a scheme for self-employed. So that was new, and the self-employed received a benefit at the social assistance level if they had lower income than social assistance. And that was also very important, because otherwise the self-employed would be without an income, and they would be tempted to go to work despite all the dangers of the virus, and the employment test, whatever, to not obey quarantine rules. All these problems could be removed because of this scheme, because it was possible for the self-employed also to stay at home and obey the rules. And finally, there was also a special scheme for the flexible workers who did not have an employer, are not really self-employed, or had not worked so long enough to satisfy the conditions for the scheme. They were also paid a particular kind of money. So in fact, all the workers and all the self-employed were covered by this scheme as far as they fall within these conditions. So that was extremely generous. It was also helpful because after the pandemic measures, the economy revived and people were still able to work the enterprises. The unemployment level remained extremely low. Also, the bankruptcy level was extremely low. So this was quite a successful scheme. The only thing is that I don't think we can do it again because it was quite expensive. So in the situation, a new solution has to be found. But it also put the protection of the self-employed on the agenda. And the self-employed always said we have to be independent and now also to be covered by the kind of social security system. So this is the pressure test for social security. So what the outcome will be is still uncertain for the future, but for the past we had some very interesting and very new experiences. Thank you very much.
Thank you to the large colleagues, which has combined both the theoretical and the practical approach. It was really interesting what it has been said about the duty to care, and the duty of care, and about which is considered as a general obligation, but there is also a kind of individualization of the obligation during the pandemic, and especially during the pandemic, and this is very interesting. And it is as well interesting the new approach with the involvement of the social partners during the pandemic. And the role of the social partners is again important as regards the privatization of our OHS legal system. I really appreciated some of the practical approaches to the pandemic, to the issue. I mean that I think it is very important to have underlined the role of small and medium enterprises during the pandemic, which in my view, small and medium enterprises have been affected a lot during the pandemic, more than large enterprises. And also it was really interesting the pressure test for social security. And I would like to especially underline again the fact that self-employed are part of the social security legal system in the Netherlands, and also that particular attention to some of the most vulnerable workers, employees, such as flexible workers, as you said before. That's really nice to from you to have underlined those aspects. Now it's the turn of Germany. Eva Kocher, I think you have to. Yeah, okay. Eva Kocher is from the European University Viadrina in Frankfurt. Eva, the floor is yours.
Thank you very much, Eduardo and Massimiliano, for organizing this panel and giving us the opportunity to reflect on some more issues that raised out of this COVID pandemic. It's good to speak after the Dutch colleagues because I want to talk about more or less these issues, and I want to use them as starting points for some cases that have been interesting in Germany. First, the system of OHS protection, and secondly, the social security system. The first case, I also want to value that we are in Naples, where I say soccer and Maradona are very important, and I also want to give you a case that has to do with soccer. You should wait for it. Well, first, Jane said that the Netherlands had already changed their health and safety protection system before the EU directive came about. For Germany, the EU directive was really a difficult instrument. because we had changed our system. We had a system that said the machine and the offices, they should look like this, and very strict public regulation of health and safety, which said, they told the employers in detail how working places should look like. Now, the Health and Safety Directive of 1989 works completely different, as you know. It establishes this duty of care and what we call a procedural approach. It doesn't tell the employer what to do. It tells the employer to make a risk assessment. And then in Germany, it's up to negotiations with the works councils, similar to the Dutch system. But that was very new, and it took many, many years to implement. And still, trade unions are really struggling to get those risk assessments, individual risk assessments for every working place in all the countries. It is really a daily struggle, and it used to be like that for years and years and years. And the COVID pandemic highlighted the dangers of this system, which in general I think is a really good system, because especially if you consider health issues, mental health issues, or psychological issues. You need individual risk assessments. You couldn't prevent these risks in different ways. You need individual risk assessments. But how can this be implemented? So this is something the COVID-19 pandemic highlighted. And well, I want to start with some cases. Nowadays, if we have major outbreaks of the coronavirus, it's mainly in schools. But at the start of the pandemic, the schools were closed, at least in Germany. Schools were closed, and we didn't have any major outbreaks in supermarkets. We didn't have them in public transport. We didn't have them, not even at illegal parties. No outbreaks. The outbreaks we had were at workplaces, and they started at workplaces. And the very first case of COVID-19 in Germany developed at a workplace. That was an automobile supplier in the Munich region. And they worked with some Chinese equipment, so they had a Chinese technical expert giving them a course, some advice on how to use the equipment. And this Chinese expert, she was COVID positive. She was tested afterwards, and this was the first spread of COVID-19 in Germany. And after that, for months, every time there was an outbreak, you could trace the origin to a workplace. Although we had all these measurements, this risk assessment, and the employers had to establish a hygiene plan. So they had to look at their individual workplaces and establishment and establish measures. So all that was in place, and nevertheless, we have these outbreaks. So the pandemic highlighted, and they showed the problems that have been there for a long time. And the most important case, very interesting case, that has to do with soccer in a way, because as you may know, soccer in Germany is very closely connected to the meat industry. You may know that Uli Hoeneß, who was the manager of Bayern Munich for a very, very long time, he is a manager also, and he's the owner of a meat company. And Schalke 04, who also, no, Schalke 04, it's also a very important club. Now it's second league, but it will get up again. It has a main sponsor and a director, Chinese, who is the owner of a very important meat company. So that's a very close link between these industries. You also know that there have been very many problems with COVID outbreaks in soccer. This is also a workplace. There's even been a soccer coach who was dismissed because he used the fake green pass. But this meat industry, this is what really brought government to actions. And this shows some traces that trade unions have been addressing for a long time. First, these are working conditions that are very harsh. And you know that there's violence being done to animals. And this is a violence-infected workplace, in fact. So this violence kind of permeates also these workplaces. They use lots of subcontracting. They formerly used a lot of so-called self-employed people from Eastern Europe. This goes back to the time when the freedom of movement of workers was not completely guaranteed in the newly accession countries. And so there was freedom of services, but not yet freedom for workers. So they used self-employment and services. That was a practice in the meat industry. They had lots of self-employed Eastern Europeans. They had lots of subcontracting. And there was a major outbreak at one of these workplaces, which spread throughout the town even. Hospitals filled. And Tönnies, the owner of that firm, he said, we cannot trace because these are not our employees. We have very few employees. We have all these subcontractors and they are responsible for tracing because that was an obligation at the time, but we don't know anything about it. So they couldn't trace back infected persons at the time when this was very important, although it was obliged to do so. He said, well, I don't collect the names of them, we don't trace them, we don't know nothing about them. And that led government very quickly to action that trade unions had been asking for years and years and years. It took, I think, 6 or 8 weeks to make a law which bans subcontracting in the meat industry. It was before that, everyone or many lawyers said, oh, that's constitutionally not possible. It's very difficult. You cannot ban subcontracting because it's a freedom of the employer, etc., etc. But in that situation with COVID, they said no subcontracting in the meat industry. Was limited to meat industry, but it's a very interesting case, I think, because these constitutional issues, they are now out of the way, and maybe we can see more of them, hopefully. So that's one interesting case where I think this discussion hopefully will stay with us, because subcontraction is a very interesting and very difficult issue in many industries. Now, the second issue I wanted to talk about, this has to do with social security, and I will also address the question that Massimiliano Tufino raised about the important role of, in this case, the labor law judges. I will talk about more or less the cases that Franz also talked about, the closing of non-essential businesses, and the way the government treated the danger of losing jobs in all those non-essential businesses that were closed or had to be partly closed in order to prevent contact. We have an instrument in the Social Security law, which is called short-time work, or Kurzarbeit. It's similar to unemployment benefit. It's also paid by Social Security, by the Federal Labor Agency, but it was only applicable if the firm had to be, the establishment had to be closed due to economic reasons. And they extended this to the pandemic reasons, and they put lots of money in it. Olaf Scholz, who is now the Chancellor, he was the Ministry of Finance at the time, and he used a rather military expression. He said, we'll take the bazooka. So that means the bazooka of money. And that's what they did. So they took a lot of money to finance and to keep jobs. And they also extended these rules to the self-employed, similar to the Dutch case, because self-employed did not have any of these benefits, but they extended them in small steps to the cultural workers, to other self-employed, and they lowered bureaucratic requirements. It was very easy to get these benefits. You didn't have to prove very much. So it was really very expensive program, which, well, after all, it did save jobs, but it also gave a lot of money into cases where you do not know if it was really necessary, because the bureaucratic requirements were very, very low. But to use these instruments of short-time work, you always need an agreement with the Works Council, so they're in that, and you need an agreement beforehand, so there are some requirements. It is now an instrument also being used by small and middle enterprises, but still they have a bit of a problem with forms. Most of these middle and small enterprises, they are owned by persons who are not used, they're not lawyers, let's say, so they don't like forms, they may not use them, so they close and they don't have any benefits. And then the question arose, so who pays the wages for the employees? The business is closed, the employer has not asked for short-time benefits or anything like that, so whose risk is that? And we have a rule in German law which says more or less the employer has to take the entrepreneurial risks. So if the employer fails to get contracts, so he doesn't need his employees anymore because he doesn't get any contracts, he is performing bad on the market, it would be his entrepreneurial risk. He has employed workers, he has to pay those workers, and if there's no work for the workers, it's the entrepreneurial risk of the employer. So that's the rule, and there were many labor lawyers that said, okay, this pandemic of non-essential work, it's an entrepreneurial risk, because it has to do with the kind of establishment and the kind of business you have. So in a non-essential business, being closed during the pandemic is an entrepreneurial risk. And that's where the judges came in, because there were lots and lots of court cases and very different decisions. And only last year, in the autumn, the winter last year, the Federal Labor Court decided, and it was really a change in perspective, because we all thought the Federal Labor Court would say this is an entrepreneurial risk, but the court said, oh no, this is a public issue, this is a public health issue. So all these employees that were left without jobs and without these employment benefits due to mistakes or of the employer, they were left without any money, and they didn't profit from the bazooka.
For her presentation, I think the main word can summarize her presentation is classification issue. Since Eva referred both the classification issue in a classical sense, the problem of self-employed, subcontracting, and so on, but he also talked about, the classification issue in another sense, the classification of the risk, in the sense he really has just referred to. And it is very important what she said about short-time work and payment problems which are connected to the risk classification, as she said. And it is also important the role of the court cases, that also the Federal Labor Court in Germany. Just one thing about the first part of Eva's presentation, which was about the role of the European Union. She started from the role of the European Union, and she has said that the EU directive was a difficult instrument to implement in the German legal system. And it is it's another important thing to underline, since sometimes the EU directive are not a useful instrument, a useful tool, but other times that will be a problem for the national legal system. And I think with such an observation, it's the time to split to the UK. when we talk about problems with the EU, we can also talk about the UK. Okay, so it's the time of to give the floor to Lisa Rogers, from the University of Leicester, England, UK. So Lisa, the floor is yours. 10 minutes.
Yeah, thank you very much. So I was very pleased to speak after Emma and what Massimo was saying, because I want to talk a bit about the cross-cutting theme of risk in health and safety, or the super concept of risk, as Eduardo puts it. So I think this is an important theme, and I think COVID-19 has challenged the way that we think about the regulation of risk, and risk regulation being part of health and safety. So COVID-19 represented a certain kind of risk, a novel risk, risk that was poorly understood, risk that was variable, but also at the same time a risk that was widespread. And I think having this new kind of risk in the workplace and for workers changed the landscape of health and safety quite significantly. You can see it in a sort of small iterative way, or you can see it in a more fundamental change to the system. Similarly to Eva, in the UK, there has been something of a shift from risk-based regulation based on industry. So traditionally in the UK, the health and safety regime was focused on certain workplaces like mining, with big machinery, agriculture, it is focused less on workplaces such as shops, offices, which are seen as low risk. But of course, during the COVID-19 pandemic, the risk profile changed between workplaces. Some workplaces which were previously high risk or were not so high risk now, and vice versa. So that was interesting. And also the risk of COVID was difficult to classify. So in some respects it could be seen as low risk, but then because it was so widespread and has such differential effects for people, it was also high risk, so it was difficult to classify. And it was a novel risk as well. So data, especially in the early days, nobody knew what they were doing. The data was difficult to collect. It was a hidden problem. And so all of this, I think, changed the risk profile and the way in which we could think about the regulation of health and safety as a risk-based activity. So on the one hand, with a novel risk like this, you can try to adapt in small ways the regimes that we already have. So increase inspections, as we saw in Group 4, talking about, and increase enforcement possibly in these newer areas, or you can see it as changing the way in which the regime operates. So focusing away from the workplace, as Eva was saying, towards the worker as a more effective way of regulating health and safety. And I think the benefit of that as a labour lawyer is to see that you can move to a more rights-based approach to health and safety. So you can come back to the moral element, which in the UK informed our first health and safety legislation, but has been kind of lost as we've moved to this risk-based, cost-based sort of analysis of risk. So it allows you to make important distinctions based on the particular vulnerabilities of workers, which is not possible when you take a work-based approach. And also taking these kind of risks more seriously, the new risks, as it were, which are always there but not, but we're hidden, like mental health and so on. And I think workers, as we can see more that workers are risk bearers as well through the pandemic, and that status has a big impact on health and safety experiences. So in the UK, we have a lot of problems with status, as was mentioned in the presentation. So PPE was only available legally to employees, and many self-employed persons are excluded completely from health and safety law. And so as we move to the endemic stage, perhaps we can think about shifting the focus of health and safety to more towards the worker and less towards the workplace. And that's what I wanted to say. Thank you.
Thank you, Lisa, for her presentation, which was mainly based on risk regulation. Lisa has said to us that the risk regulation has changed with COVID-19. So also in the UK, there is a problem of risk classification, the adaptation of the health and safety regulation to the new risk of COVID-19. So that's very interesting. And it is also interesting what she said. She has said at the end of her presentation when she referred to the shift from the industry to the worker, and that's a very important thing. Even though there are some problems with some kind of workers in a wide sense, as she said, self-employed people and independent contractors are not covered by the health and safety regulation in the UK. So that's another very important topic. And now it's the turn of Italy. So with the presentation, the presentation shared by Eufrasio Sena and Emilia Davino, who are both from the University of Naples University. So Eufrasia first.
Thank you. Well, I'd like to start from the title of our seminar, COVID-19, a pressure test for occupational health and safety. So my colleague Emilia and I were wondering if this pressure test actually worked here in Italy, and also whether there is an experience gained during the pandemic that can be applied in the management of OHS, even outside the specific scope of virus control. And on the other side, if there is something that didn't work or didn't work well and could be improved. In this reflection, I will deal with the national level and my colleague with the company level. At national level, I believe that the Italian OHS system passed this test, and that the opinion on the Italian experience could be positive. Surely, in the first months of the pandemic were very difficult due to the lack of adequate scientific knowledge on the characteristics of the coronavirus and its methods of transmission. And also because Italy was the first European country, the first country outside China, to have been strongly affected by the infection. But beyond the inevitable initial difficulties that led to a wide lockdown, the subsequent management of the fight against the pandemic in the workplaces has allowed the continuation of production activities without offices and companies turning into hubs for the coronavirus. In this framework, I believe that government decision to actively involve trade unions in defining and implementing the procedures to counteract the spread of the virus in the workplaces was very useful to the achievement of this goal. There was the need to regulate health and safety in the workplace, but it was impossible for both technical and temporal reasons to enact a specific regulation for any production sector and for any type of company. For this reason, since March 2020, at the beginning of the pandemic, shared protocols have been signed between government, trade unions, and employers' organizations, and they have been progressively updated. And already one of the first decrees of the President of the Council of Ministers dedicated to the pandemic on March 11, 2020, provided for the closure of the majority of production activities, leaving open only those ones deemed essential, and for the identification of general rules for the protection of workers' health and the containment of contagion, recommended that for the practical implementation of these measures, there were agreements between unions and employers' organizations. In this way, a participatory management of the safety at work has been put into effect, involving trade unions at all levels, from the national protocols up to the representatives of the safety in the company. I think this choice might be important and useful for the Italian trade union system too. In Italy, in the last decades, trade unions has been facing a crisis of representativeness, and they often fail to be real interlocutors of workers' interests and requests, because workers no longer felt represented by the unions and did not hesitate to disavow their agreed, not trusting their ability to correctly interpret the needs and demands of workers' community. We can consider, for example, the referendums proposed in 2010 by Fiat Automobiles, now Stellantis, to the employees of two plants, and concluded with only measurement approval of company's proposal. For the referendum on the Alitalia agreement in 2017, rejected by employees, even if not only trade unions, but also Italian government have strongly supported it. It is surely a crisis whose scope goes beyond trade union boundaries, because it's part of a more general difficulty of the so-called intermediate corps, also political parties, for example. On the other way around, I think that during the pandemic, the role of the unions was decisive. Maybe also because in situations of emergency, as a pandemic, but also as a war and its economic consequences, the importance of intermediate structure to manage some critical issues is particularly apparent. So I believe that the trade union consultation carried out during the pandemic could usefully be applied to other issues relating to safety at work. Occupational accidents, sometimes fatal, require a culture change rather than a regulatory one. Safety should not be perceived as a cost by either employers or employees themselves, but as an opportunity. There are many rules on occupational safety as well as on inspections, and there is a system of sanctions recently also strengthened. But it's clear that the labor inspectors can be present every day in every plant, and the stronger involvement of trade unions at a national, local, and company level could be the right way to promote the safety culture. Even in a widely regulated system such as the OHS, trade unions can play a role in translating provisions into concrete practice, demonstrating the importance of the social partners for the functioning of prevention systems. On the other side, is there anything that did not work or that could work better in Italian management of safety at work during the pandemic? Yes, of course. I think it's the link between the occupational safety system and the local health service. To be honest, more for problems related to the management of the latter and to the political choices about it than for issues related to the chess. It goes beyond the scope of our meeting to analyze the functioning of the Italian health system, but I believe that the pandemic has shown that health is also guaranteed through a capillary and effective local medical service that I think should have a close link with safety at work. Thank you.
As already said, I focus on an individual perspective and company level, and in particular on the employers and employee obligation in Italian system of health and safety system, obviously. I think that also in this perspective, the pandemic emergency has provided an opportunity to focus on some important issues. First of all, I think that many questions has already been raised, such as the privacy, the green pass control, or the problems about the payment of the workers. But I focus on two aspects in particular. The first is the adequacy of our system to include any kind of measures despite the changes of the time. In particular, the Article 2087 of the Code is a general clause that could include all kinds of measures that could prevent all the occupational and safety risks, including biological risks such as the risk of COVID. But obviously, I think also in the perspective of employers' liability, it's important to integrate this article with the collective bargaining and the legal framework for two reasons. The first reason is that a general clause could generate a probably discrimination or a distraction, not a uniformity of measures in the Italian system. And second, that, as already said, it requires an ex post risk assessment, probably left to the judge system, to the judge discretion. So it is for this reason probably that the legislator during the pandemic emergency introduced a norm that provides for the exclusion of liability employers in case of due complying with the protocol such as already adopted. So I think it's the first important topic arising from the emergency. The other issue that I think is very important in my opinion is the attention in an opposite perspective. That's to say the workers' duty to cooperate. I think that also the debate on the compulsory vaccination here in Italy for certain categories of workers have to be interpreted and analyzed in this perspective. That's to say the workers' duty to cooperate. Obviously, there are obligations for employers, but also for employees. Particularly in Italy, this debate is a topical issue, but really it is a wider debate, and the Constitutional Court on this topic already made an important contribution in the past. In particular, on the topic of compulsory vaccination in some category of workers. And the court must always focus on the proportionality and reasonableness of the measures and the compulsory vaccination, considering two aspects. First of all, the balance between the individual risk and the collective risk assessment. So that's to say, I read the court, any compulsory vaccination is not incompatible with Article 32 of the Constitution under the following condition: if the treatment is aimed at to preserve the state of community health, and if it does not affect the state of health of the person subject to it, except for those consequences which appear normal and therefore tolerable. So this is a matter to be solved by an individual and collective risk assessment. But I think that is an open question, particularly because is raised in March in order of refer to the Constitutional Court on the legitimacy of this framework, and in particular on the legitimacy of the suspension of obligation to work and the payment for workers who don't comply with the compulsory vaccination. Concluding, and obviously is a balance between the right to work and the compression of the freedom of health self-determination. But there is an administrative rule recently that established this the vaccination obligation imposed on healthcare workers is not only a provision responding to an obligation of safety and protection in its workplace in contact with the public, but also to the equally fundamental principle of safety of care, responding to an interest of the community, and in this perspective, it is an interest certainly prevailing over the right to work and the right to self-determination freedom. So I think that in this case, also, there is an important rule of the judge and the constitutional court. The question is open.
Many questions are open after the intervention, presentation of the Italian delegation, since as Francia Sena has reminded us, Francia talked about the role of, particularly about the role of trade unions, of the social partners in combating the pandemic, the COVID-19 pandemic. And she has underlined that maybe COVID-19 could be a best practice for restoring the trade union system in Italy. And especially to combat the trade union crisis, which have been affecting our legal system, trade union system, since last decade. She has mentioned the FCA, the Fiat Chrysler Automobile case, which is very important. But I think we have to wait. We don't know if COVID-19 can be considered as a best practice for the role of social partners. So we have to wait next month in order to understand what will happen with trade unions. While Emilia Davino has underlined the role of the individual level, of the contract of employment level, and especially of the provision concerning the risk assessment. So starting from Article 2087 of the Italian Civil Code, the well-known general clause contained in that provision. It is very interesting that Emilia has underlined twice the role of the judges. Since she, first of all, she has underlined the role of the judges in the so-called ex post risk assessment. So we have to wait here in order to understand which kind of role are going to play the judges in our legal system. I mean the ordinary judges. While she made a reference, she has made a reference to the Constitutional Court, to the role of the Constitutional Courts. Now, in this case, there is a decision, a judgment by the Constitutional Court, and about the vaccination of some categories of workers. And she has underlined also that the Constitutional Court has used, as usually, the so-called balance test in that case. So that's very important since this is typical of the intervention of the Constitutional Court in such cases. So I think it's time to give the floor to the conclusions, which Alice, which is, as everyone knows in this room, is from the University of Naples, Partenope, and so Eduardo, it's up to you to conclude this seminar.
Thank you. Thank you, Massimiliano, for having accepted our invitation to chair this roundtable. It's always a pleasure have you with us. You're such an expert on Euro and comparative law, so thank you very much. I will not conclude on the topic of the seminar. I think you really did a great work in the groups, and the round table was also impressive as kind of contribution to the debate on such a complex issue and also hot issue, unfortunately made hotter, even hotter by the pandemic. I would like to conclude on, well, the meaning of such seminars, and also, in my view, the meaning of a group like the EWL, which, as you may remember, was established more than 20 years ago. So it's not yesterday. It's a long-lasting experience of scholars and friends working together for a common goal and with a common mission, I think. And I still believe that there is a spirit in such kind of seminars and groups, which is based, in my view, on 3 basic values. They are linked to comparison in a way. So we compare because we believe in some values. And the first value is curiosity. So we are curious about what is happening in other countries. We would like to know more about it. And the aim of the seminar is to stimulate your curiosity. And if, as students, you accept to be part of the seminar, we assume that you are curious about what is happening elsewhere than your country, because otherwise you will stay home and just study your national law. So curiosity means that we have to leave outside the door any prejudice. Because of course there are differences, of course there are people talking a bad English, people reading their reports and whatever you may not like. But it's a part of the game. And it's part of the curiosity, also learning to understand how difficult it could be for people who are not talking in perfect English because of their not mother tongue or very expert to prepare a report, which maybe is not 40 pages, only 40 or 14. So it's a kind of leaving aside the prejudice. Which brings me to the second point of the seminar and of the group, which is respect. We would like to generate respect, reciprocal respect. We would like to generate reciprocal respect because otherwise we will end up like in 1914 or 1939 or in 2022. So that's the real aim. That's at least what I'm interested into when we gather together students from different countries, which have different traditions, different cultures. So what we have to leave aside the door is superiority, this feeling to be better or more. So leave aside also the fact that there is a best solution, a best system, because we are the starting points, the economic origins, the historical developments of each country. Maybe we have to always bear in mind which is our history and where we are coming from. And the third point is about cooperation. I try to put focus on cooperation at the beginning of the working groups, because this, I think, is the added value of people coming from 4, 5, 6 different countries working together. Otherwise, we stay home and we make good working groups at national level. Cooperation means also to leave out of the door competition, because this is not a contest. The result is a common goal, and I think that if we all go back home knowing something more about our system and other system, that will be a nice thing. And if we go back home with a good feeling, so having worked together, you did great presentations. I think this is the goal. It's nothing else. So the fact that the miracle putting behind this table people from such different countries and traditions presenting a common result. So this, I think, it's about Europe. It's about being a group of scholars, being a group of students, and therefore, I think if we achieve this, then it has been worth all the effort and the money put, of course, in this kind of seminar. And I do really hope you will go back home with this kind of feeling, with this kind of thought of curiosity, respect, and cooperation, because maybe then you can also spread this kind of positive virus, not only COVID-1, but the positive virus of giving a value to this kind of experience, and also give us a reason to keep organizing this kind of seminars. Because I think we all, as far as in my view, we need some reason to do this. And the reason is not to show how we are good in organizing things. We are organizing things since ages, so it's not, we're not to prove us to be good in organizing a seminar. The reason is that we believe, I still believe, that this is the added value of this kind of seminars, and I really hope you will bring back with you these 3 sentiments. Thank you very much. The lunch is at the 2nd floor, so maybe elevators or the stairs. Thank you.